Don't turn that station, because coming right up, we have Professor Nick Stephanopoulos, cousin of George Stephanopoulos. More importantly, he is a professor at the University of Chicago Law School, and we will be discussing this evening, this is for those our regular viewers, this is part 2. This is not a rerun. The first show, you can find that if you didn't watch it the first time on youtube.com/publicaffairs.tv. That's where Professor Stephanopoulos lays out who's on the Supreme Court, gives you thumbnail sketches of each of the 9 justices, the voter blocks, etc. That's the prerequisite to watching this show. This show, we take it, this is sort of advanced con law 2, where we're going to talk about the voting rights decision and the pros and cons. Did they get it right, or did the Supreme Court get it wrong? But more importantly, this document, the United States Constitution, that's the tease. You're going to learn everything you need to know about the U.S. Constitution in the next 30 minutes. Don't you dare turn that dial or that station, because if you do, you're going to miss a really, 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 really good show. Yeah, so just give us a smile.
Excellent. The classes.
You're watching Public Affairs. Berkowitz is my name, and politics is our game. And as we told, it was a few weeks ago, the U.S. Supreme Court does have its own sense of politics. It did decide Gore v. Bush in favor of Bush in some way. Some would say Bush was not elected, but he was selected. Is that what the liberals who are still protesting the war of 2000, the election of 2000 say?
I think it's still a very controversial decision in the eyes of a lot of folks, liberals, progressives, Democrats, whoever. You can't easily get over having a presidential election decided by the Supreme Court.
And aside from the Iraq War, which might not have happened if Bush had not been elected, if Gore were elected, but for the constitutional aficionados, Chief Justice Roberts was appointed by?
Chief Justice Roberts, also Justice Alito. So the current court would look very different if Gore had been president for those 8 years instead of Bush.
And in a sense, maybe that is the most important thing about the election of the President of the United States. He gets essentially to appoint to nominate about 900 judges, which according to this document, the U.S. Constitution, must be confirmed by the Senate.
By the Senate, that's right.
With advice and consent. But still, and especially the U.S. Supreme Court, some would say that's what the battle is really about in 2000, 2004, 2008, 2012, coming up 2016, every 4 years. That person picks may have an opportunity to pick Supreme Court justices because they're there for life. Mm-hmm. So it's a matter of whether they die or resign, and if they do, when somebody's president, they get to appoint.
Sure. So it's one of the big issues in any presidential election. Is it as significant as taxes, war, healthcare? Who knows? But it's certainly one of the really big issues whenever candidates face off.
Well, yeah, one of the really big issues, but you just mentioned, there's taxes, healthcare. But remember, this is really interesting because healthcare, people are talking, we're taping the show on November 2nd, and that's all the rage, the discussion of Obamacare. But, Obamacare is Obamacare because?
Well, it was passed by Congress and signed into law by the president, and then the court approved the constitutionality of the law as well. So you had all 3 branches, in a sense, agreeing about it. But it wasn't the court that ever initiated the law. It was the court that just, in the end, declined to strike down the law, which is something different.
Right, but had they stricken the law,
then there would be no more Obamacare.
Which, according to Marbury v. Madison, they have the last word. And interestingly enough, tell us about that decision. What was the vote in that decision? Who wrote the opinion? How does that decision fit within the voting blocks that you and I discussed on our last show, where we had 4 conservative justices, 4 liberals, and we said the swing vote was?
Justice Kennedy, who, to the surprise of a lot of observers, voted with the conservative bloc to strike down all of Obamacare. So in
So
that
he was
decision,
not the swing
he was
vote.
not the swing vote in that case.
And who was the swing
So
vote?
Chief Justice Roberts ended up being the swing vote, to the surprise of a lot of observers. Very few people would have predicted that the Chief Justice and not Justice Kennedy would end up writing the opinion upholding Obamacare.
So what happened? Would you have predicted that?
No, I certainly would not have predicted that. I would have thought that Kennedy on these sorts of issues is more to the left than
Wouldn't
Roberts.
Wouldn't you have predicted that Kennedy would have voted to declare it unconstitutional, Obamacare, and wouldn't you have thought that Chief Justice Roberts would have voted that way? And somehow, wouldn't you have thought that decision would go 5-4 for sure if Kennedy went with the conservatives?
Yeah.
Weren't you really shocked that it was Chief Justice Robert who cast the deciding vote to say this law was constitutional?
Yeah, I was quite surprised. I think that if I was being optimistic before the decision, I would have hoped that Kennedy would have come around with the liberals. And so people in the wake of that decision have speculated that maybe Roberts' position as the Chief Justice makes him more aware of potential institutional consequences for the court. And so he might not want to put the court in a position where it's striking down the most important legislation that a president supports. That's exactly what happened in the mid-1930s with the New Deal and Franklin Delano Roosevelt. And in the eyes of many people, that was the darkest hour for the court. That led to one of the court's greatest confrontations with Congress and the president. And Roberts may not have wanted to repeat the history of the mid-1930s.
Well, what would have happened if in fact Roberts had, with Kennedy, voted to declare this law unconstitutional? Would that be a dark day for the Supreme Court? Would there be a coup? Would Obama declare the Supreme Court itself unconstitutional? Seriously, would there or would he just say he would criticize the court? That's what would happen. He might criticize the court. That might not be good for the country. But we're not really predicting a crisis, would we?
I don't think we would have a crisis in the sense of coups and mobs on the street. But I think we certainly would have had a real crisis of legitimacy for the court. For the court as 9 unelected justices to step in and decide that the most important piece of domestic legislation of a sitting president is unconstitutional. Those are earth-shattering events in our political system. So you can believe in the court having the power of judicial review and still think that the court should exercise that power in a very delicate, very deferential manner. And when you have legislation like healthcare that seems to fit pretty well under decades of precedent on the Commerce Clause, this doesn't seem to be an incredibly novel or bizarre thing for Congress to be doing. So for the court to invalidate this, I think would have invited a significant crisis and really would have undermined the court's legitimacy.
And so, but if you were there, if you were on the court, okay, your inclination would be to say that this is constitutional, right?
I would say that
Obamacare
it's a reasonable exercise of Congress's power under the Commerce Clause.
Where's the Commerce Clause?
It's in Article 1 of the Constitution, where the powers of Congress are set out. So Congress has the power to regulate interstate commerce.
And do you think that's really what the framers had in mind when they were talking about that?
I think as long as the framers chose language that is so abstract that it can easily accommodate the meaning that the current Congress wants to put on the words, I think that it's fine. If the framers wanted to rule out this kind of activity, they could have and they should have chosen narrower language. And let me just also point out, the main goal of the framers was to have an energetic, powerful federal government. They were responding to the feeble government of the Articles of Confederation. So their main inclination was to have more power at the federal level. And sure, that doesn't mean complete power, but they made a deliberate effort to write in pretty broad terms the powers that Congress would have. And so my view is that when you start with language that is quite broad and that's easily consistent with the interpretation that both the president and Congress put on that language, then the court should stay out of it, and the court should defer to the conscientious and informed judgment of the political branches.
Well, I was looking for my notes on the 10th Amendment, and while I'm doing that, maybe, I don't know, it's gone away. Maybe
that's for the better.
Maybe they'll find it in one of our graphics for the 10th Amendment. Because the 10th Amendment does what, essentially?
So it says that powers that are allocated, that are not allocated to the federal government, are reserved either for the states or for the people.
Right, and so basically, would that be the most important amendment for setting out sort of the federalism principles in the U.S. Constitution?
It's probably the most explicit single place where you have the principle of federalism set out.
Okay, let me just
it's also inherent.
Let's read it.
Sure.
This is almost working better. I don't know for some reason why I didn't find it in my notes, but the graphic, and you don't have to look at it, so I'll read it for you. The 10th Amendment, the powers not delegated to the U.S., the United States, by the Constitution, nor prohibited by it to the states, are reserved to the states or to the people. So the framers thought in this U.S. Constitution, tell me if I'm wrong, that basically it starts by setting out powers that Congress has in Article 1, and then Article 2 says the powers that are given to the president, and then Article 3 to the judiciary. I was taught at the University of Chicago Law School that
a great institution.
that was not just random. Article 1 was because the framers viewed the Congress as the most important entity of the three branches of government. So they were Article 1. The president, second most important. They viewed the judiciary as least important, third. Okay, and then the 10th Amendment, when was the 10th Amendment passed about?
Well, so it was part of the Bill of Rights, so just a couple years after the Constitution itself.
Which was ratified in 1787, right?
Sure, yep.
So a few years later, the 10th Amendment, it sets out this principle. It says, look, we gave the Congress certain powers, but unless they're specifically prohibited, specifically enumerated, that any other power is left for the state or the people, right?
Yeah, you can see the 10th Amendment as just being a restatement of the obvious. So you have Article 1 that sets out what the powers of Congress are. So a pretty clear inference from Article 1 is that if something isn't granted as a power to Congress, then Congress doesn't have the power to do it, and somebody else may have the power still to do that thing, and that somebody else might be a state, or it might be the people themselves. So, courts have not thought that the 10th Amendment adds a whole lot substantively to what we already had in the Constitution. It just restates the point that if you don't grant a power to Congress, then Congress doesn't actually have that particular power.
So what we're doing here, folks, in a sense, what we're doing is, in a sense, starting to talk about how people construe this document. The Constitution, right here. Keep losing it. There are different ways to do it, right? What are some of those different approaches?
So originalists would say that we begin by looking at how people at the time that a particular provision was adopted understood the words of that provision. So not what the framers intended, but how people generally in that time period would have understood that language. Then you might say that we'll start there, but we're also going to be very concerned about how the courts themselves have interpreted this language over time.
Which would be precedent.
So another approach would be to focus on precedent and focus less on the text itself and more on the evolving body of case law that the courts have come up with.
And not just specific, like what case or precedent this case decided this way, but precedent in the sense, as you say, how the courts, the Supreme Court in particular, discussed the specific provision in the Constitution. So in a sense, the case law in the United States Supreme Court interpreting the Constitution. So things move rather slowly in the United States and in the U.S. Supreme Court. People spend a lot of time looking back at Supreme Court decisions, and sometimes people would say, well, that's an old decision. And they may criticize it that way. Others might say, well, the older the decision, the stronger it is because it's been around so long. Which way do you go?
I think that a lot should hinge on how persuasive we still find the decision. I don't think the age of a decision by itself tells us all that much one way or the other. Although I would say if we're originalists, then the age of a decision might be useful because an older decision might have more insight into how people understood certain
Way back
texts.
when, and whereas that, as opposed to the modern folks. I mean, what, Justice Breyer, if he wrote a decision 2 years ago, Scalia may say, what the hell does that matter? He's just a guy. But if somebody wrote a decision 150 years ago, well, that person was very close to the meaning of the Constitution.
And you see, that's why we refer a lot more to Marbury v. Madison and McCulloch v. Maryland than we do to the many, many other cases that have stood for the exact same points as those cases.
But the really major decision, we were just talking about this before the show. Your specialty is what?
Election law, so the intersection of law and politics.
And it's interesting because about 50 years or so ago, 1962, is that when Baker v. Carr was?
Either 61 or 62,
62.
I believe 62.
So
and I really
that
ought
would
to know
be
the exact
about a
year.
half a century ago, just about a little bit more. That was really a major change because if you had been going to law school then in the 60s and even in the 70s, you would hear professors talk about, not professors, you would read cases where the Supreme Court said, we can't decide that. That's a political question. And so there are all these questions that politicians are supposed to deal with, and the Supreme Court would defer. It would be non-justiciable. Is that what they say?
Right. They would say that certain matters are ones that are covered by the Constitution, but still there's no standard that courts could come up with to decide these cases. And so in the absence of any standard that courts could use, the power to decide those issues should be left with the elected branches.
In that decision, in that viewpoint, I think Gerhard Casper would say something like, he'd use that word, I think it's desuetude or something like that. That's a concept or doctrine that's fallen into almost non-use for the last 50 years. For the last 50 years, that concept of a political question has been slowly but surely, maybe not so much slowly, eroded.
I think that's right in broad strokes. So there's still particular areas like partisan gerrymandering where the court does apply the political question doctrine.
That would be about the only thing left.
That's right. So if you look at one person, one vote, if you look
Which
at
was decided
minority,
when?
These are the cases you referred to in 1962, 1964.
And what, for those who might not know, why is one man, why is one, it's interesting because it says something about how we looked at things in terms of gender then. The phrase was not one person, one vote, it was one man, one vote, right? And
must have evolved at some point in the 70s from one man, one vote to one person, one vote.
That's what we say at the University of Chicago.
And so
if we don't want to get lynched by the women's group.
And so what the case said was that you can't have electoral districts for Congress or for state legislatures that vary dramatically in their population. So one person, one vote means that all electoral districts have to have about the same population.
Okay.
And before that, the court had said that we think population equality of districts is a political question. It's a question that Congress and the people and the president have to deal with, but it's not a matter for the courts.
But the Senate is clearly not one man, one vote because you have a small Senate like Delaware. Is that where Biden comes from? Is
It is,
so?
yeah.
So two senators from Delaware, which you could almost fit into Hyde Park, count the same as two senators from California, the most populous state, has, I don't know, 30, 40 million people now? Something like, some enormous number.
Yeah, California is massive.
Massive. So how can the court say what we just said about these numbers and yet allow the Senate to have, each state has, only two senators? Shouldn't California have 50?
Well, I'd be fine with that. I think that's the right approach, but it's not the approach.
You're just kidding, of course.
But it's not the approach of our Constitution. Okay. So I think the court would say that there's a general principle of population equality, but the court has to recognize a textually authorized.
Where is that general? Is it here in the United States Constitution?
It emanates from the words equal protection under the law.
The 14th Amendment, which
says.
says.
So it's the court's
we have that right
interpretation
here.
of the 14th Amendment.
The 14th Amendment says.
So nobody shall be denied the equal protection of the law.
Okay, so we can maybe get that graphic up there. Yeah. Nor deny to any person the equal protection of the law. That's the Equal Protection Clause. The other clause in the 14th Amendment is the due process. Nor shall any state deprive any person of life, liberty, or property without due process of law. So equal protection of the law, you're saying, this Constitution. So the originalists, would they agree with you that when they wrote that in the 14th Amendment, okay, and they adopted that, they were thinking one person, one vote?
I think originalists would almost certainly say no. They would say that if you looked at how the framers and the people back then thought that this phrase would be interpreted, they almost certainly didn't have in mind population equality from district to district.
Okay.
To which the court back then, and I might respond, if the framers make the decision to use language as broad as equal protection of the law, then they have to live with the consequences. The decision to use language that broad is a decision to delegate interpretive authority to future generations of the American people. So if you want to tie the hands of the future, you use more specific language. But if you don't want to tie their hands and you use really abstract terminology like this, then you might get decisions that you didn't expect down the road.
And on the court now, certainly Justice Scalia would disagree with you.
Unclear. He says that we have to.
He's an originalist.
He's an originalist, and I would say what I just said is originalist as well.
He might agree with you, Justice Scalia?
Well, he would agree with me that we have to look at the original meaning of the words. And equal protection today means the words haven't lost their meaning or changed in their definitions.
But he wouldn't say what you said. If the originalists really wanted to have this be confined, they should have used narrow language. Scalia wouldn't say that.
Yeah,
right?
so I would say the key.
I'm saying Thomas wouldn't say that, right?
The key distinction.
Those two guys would distinctly argue. But what about Alito?
And
what about Robertson? What about Kennedy? They might agree with you?
Yeah, I don't know. To any originalist, I would say that if you would disagree with me, you have to explain why you think the key principle is original expected application of the language as opposed to original meaning.
Okay.
Like an original, I can be a liberal originalist and say that I am being true to the words equal protection and their original meaning. Sure, I want the words to be applied in a different way today than they would have been applied back in 1867, but that's just being consistent with the breadth and the vagueness of the language.
And Breyer and Ginsburg and Sotomayor and Kagan, they'd all agree with you.
I would say, in effect,
Look, they're very liberal. I say this with all due respect. You're quite liberal. Would you say that? You're not biased, but your approach is more of a liberal than a conservative. Agreed?
I think it depends what those terms mean. It's hard to pigeonhole somebody.
Would you say that Kagan and Sotomayor and Breyer and Ginsburg tend to be more liberal than conservative?
I think on our conventional left-right axis, sure.
And in that sense, you would be more liberal than conservative?
Yeah, if you
I'm
accept,
not saying it to denigrate you, I'm just saying it's a fact.
Sure. Yeah.
If I had somebody, I don't know, if I had Richard Epstein here, wouldn't he be more on the conservative
sort of
side?
on his own separate scale.
He's on his own axis. We say that with all due respect to Richard Epstein. Okay.
But if you took somebody like
Who?
Northwestern Professor Stephen Calabresi, like he would be a traditional conservative who is very similar in his positions to the current conservatives on the court.
Let's jump over to the Voting Rights Act, because that was a major decision last term, right?
It was a couple months ago, at the end of June.
End of June, okay, but it was last term, okay. And in 1 minute, what did that decision, why should the common person care much about the voting rights decision of the Supreme Court that was decided last June?
So you would say that for a long, long time, we had an awful problem of racial discrimination in voting in the South. And the Voting Rights Act was Congress's biggest effort to deal with that problem.
And when was that act passed?
The act was passed in 1965, and it was reauthorized at various points
Kind
since
of like every 8 or
1965.
10 years since then.
Yeah.
And the most recent time
Was in 2006.
Okay.
And so in 2006, Congress made a decision that the problem of racial discrimination in voting was still worse in the Deep South than in other parts of the country. And so this necessitated a special law that required only places in the Deep South, but not other parts of the country, to get prior approval.
That's what the Voting Rights Act of 1965 first did. They said there were 9 states, right, in the Deep South that did what you've said. I just want to clarify that for people. It wasn't they were saying this 6 years ago. They were saying it first in 1965.
Sure. And Congress,
these 9 states were very different, the Congress said. And so if they're going to fool around with voting rights, we want to see it before. And
Yeah.
we want to be, they have to go to the courts and almost get pre-approval before that law can go into effect.
They have to
It's
either-
almost presumptively unconstitutional unless they show us it's constitutional.
It's not quite that harsh.
Not
It's more
quite,
just
but it's-
before they make a change.
In those 9
any
states, give us a
change,
flavor. What were those?
Alabama, Mississippi, Georgia, Louisiana, Texas.
And
the
we know there
core
was a
of the
lot of
Deep South.
Jim Crow laws then that meant the government, in a sense, was in the South was enforcing segregation. This is a drinking fountain for whites. This is for blacks. And if you didn't do that, we'll throw you in jail.
And they're the same thing for voting.
For voting,
poll
for
taxes,
schools, whatever.
grandfather clauses.
A completely different world. Nobody would recognize that world, right?
I think we've moved a long way from there, but traces and vestiges of that world are still apparent. So if you look at almost any metric you want to, the Deep South is still going to look worse in terms of racial discrimination in voting than the rest of the country.
Really?
Racial
That's why
polari-
you disagree. So the majority said, the majority in the decision in June, and it was a 5-4 case?
5-4 case
written
with
by
Roberts.
Chief Justice Roberts. The usual block we were talking about, conservatives on 5 conservatives, 4 liberals. This case, Roberts was deciding that Kennedy went with the conservatives. Okay, and they said, if you folks want, well, you tell me what the majority said.
So the majority said that the formula Congress used for deciding which states would have to comply with this unusual preclearance requirement was obsolete, outdated, and therefore irrational
They
and
said it in
unconstitutional.
kind of a fancier language than I'm using. I said, the South was so different in 1965. You had this Jim Crow legislation. That's all gone. Sure, there are problems. There are problems in Illinois, whatever. But it's not, those 9 states are not markedly different, I was saying. They said it in more formalistic
Well, the court
language.
didn't go quite that far. The court only said that if Congress wants to single out certain states for this special preclearance requirement, it needs to use current data. It can't rely on data from 40 years ago.
And you say?
I say that if the formula is capturing the right places, then we shouldn't really care too much about the formal details of how the formula operates. The real crux is the product of the formula, and in this case, the product is very reasonable. The Deep South is what the formula covers, and other data confirms that the Deep South is still the locus of
what's
the
that
problem.
data?
So levels, if you look at the success of lawsuits under the other half of the Voting Rights Act, where plaintiffs are alleging racial discrimination in voting, way more of those lawsuits are filed in the Deep South, and they succeed at way higher rates.
They succeed
in the
in
Deep South.
terms of the court says you're right, or a settlement occurs, which?
But the numbers that I know include both of those kinds of outcomes.
It can be
as
fussy because
victories
if
for
it's
the
settlements,
plaintiffs.
people settle for all kinds of reasons.
Sure.
Okay, what's your next persuasive?
So then also if you look at racial polarization in voting, so how much do minority voters and white voters disagree as to their political preferences? The rates of the
but
difference.
You were saying Jim Crow legislation on one hand, and now we're talking, do blacks and whites agree?
So I would agree.
Do you see my point?
Yes. If you make the standard, if you think that the Voting Rights Act is only constitutional if you have the equivalent of the Jim Crow South, then you'd have to agree with the court and
You think
throw it
it's
out the
something
window.
else. Okay.
Yeah. In my view, this is an area where Congress gets unique deference. This is the intersection of racial discrimination and voting. Congress has a lot of power in each of those areas, and so where they intersect, I think, is the point where the courts have to be maximally deferential to Congress.
We're going to continue to speak as the credits roll. They're rolling right now. Thank you so much. Professor
Sure. Thank you.
Stephanopoulos, University of Chicago Law School, Chicago Law, where we used to say where fun goes to die.
They still say it.
Not anymore. It's a fun place.
Oh,
This stuff is so exciting. If you're thinking of going to the University of Chicago Law School, you ought to go there. And even if you're not thinking of going to law, thank you so much for coming. We need a third show because we didn't finish. In 30 seconds, what's happened in the last 40 years? All of these decisions, abortion, the court gets into everything. Capital punishment, they basically are the imperial court, right?
The court is involved in a lot of areas. I still think that other actors in our system, they're the ones that have the initiative. They're the ones that get to set the policy agenda. But the court is now involved in responding to that.
Is there a right to privacy? Is there a right for a woman to be free to choose in this U.S. Constitution?
There's a long history in the courts of implying fundamental rights that aren't written in the Constitution itself. I have lukewarm feelings about that history, but what cases like Roe v. Wade do is not unprecedented.
Do you think the court went too far in Roe v. Wade?
That's not an area where I have a clear opinion, so I don't think I can boil it down to it.